And we should be live. And I've got sound, so let's get going. And the fella studied a minute and then says, kind of sad like, well, I'm only a stranger here, and I ain't got no frog. But if I had a frog, I'd bet you. And then Smiley says, that's all right. That's all right if you'll hold my box a minute. I'll go and get you a frog. So the fella took the box and put up his $40 along with Smiley's and sat down to wait. So he sat there a good while thinking and thinking to himself, and then he got the frog out and prized his mouth open and took a teaspoon and filled him full of quail shot filled him pretty near up to his chin and set him on the floor. Smiley, he went to the swamp and slopped around in the mud for a long time, and finally he catched a frog and fetched him in and give him to this fellow and says, now, if you're ready, set him alongside of Dan with his four paws just even with Daniel's, and I'll give the word. Then he says, 1, 2, 3, git. And him and the fella touches up the frogs from behind. Ooh. And the new frog hopped off lively, but Daniel give a heave and hoisted up his shoulders so like a Frenchman, but it weren't no use. He couldn't budge. It was planted as solid as a church, and he couldn't no more stir than if he was anchored out. Smiley was a good deal surprised, and he was disgusted too, but he didn't have no idea what the matter was, of course. There, we'll leave it there for that. Do you like my animation of the tadpole's tails? I've been working on the animations. Anyhow, let's kill the tadpole tails. And let's get on to a contract. Not that one. That one. Good evening, people. Or good morning, or good afternoon. What if a contract appeared, apparently between a company whose name begins with E and has a principal place of business in Nevada, and someone called Colin, who's an independent contractor? I will just warn you that this contract is not signed. So it's not a signed copy of a contract. So I can't verify whether or not this contract is the contract. However, if it isn't, someone's gone to great lengths to draw up something. So I thought we'd look through it. I haven't watched all of Colin's streams, but or his streams on streams. So we'll see. Some of you will have, and we'll see if it, sort of matches. So it was made on the 3rd of April, or apparently made on the 3rd of April, 2023. I have been quite broad with my whiteout, because obviously I don't want to get struck for doxing someone. And these could be random people. Someone called Colin and someone whose company begins with E. Right, services to be performed by contractor. So he's a contractor, hypothetically speaking. So he's acting independently and not as an employee of client, agrees to A, create new clips from D, video content, when there are opportunities for meaningful segments to have broad viewer appeal, and publish those clips into something clips reloaded with custom thumbnails. I've no idea whose channel that is. Promote something clips. Contractually, you probably ought to repeat the name of something the same. Right, promote something clips using premieres and other YouTube features. Moderate comments in something clips reloaded by deleting spam and comments that have no constructive value. send out free trifolds and promotional digital items to recipients provided by client, make irregular trifold videos and post them across some channel beginning with Z. Contractor warrants that he is qualified to perform the services and that the services will be performed in a professional, timely and workmanlike manner without the advice or direction of client. Failure to perform all the services required under this agreement constitutes a material breach of this agreement. Qualified. I wonder, that's quite an interesting. Who determines whether or not you're qualified to provide those services? I don't know. Method of performing services. The contractor will determine the method, details and means of performing the services. He may perform at any suitable time and location contractor chooses. He's going to use his own resources, such as supplies, equipment, tools and materials, to complete the services, unless necessity requires the use of client's resources and premises, as those requirements are defined in the agreement. He shall devote such working time and attention to the performance of the services as required to satisfy all duties and responsibilities of contractor in finishing the assignment. Contractor agrees to devote a minimum of 5 hours per week to performing the services. Minimum. Contractor shall perform his obligations hereunder in compliance with the terms of this agreement and all applicable laws and regulations. I'm just going to have a quick look at chat. We might at some point have a quick look at who's in the Frog Club. Right. Okay, sorry, just having a quick look at chat and seeing how many concurrent viewers we've got. See if it's worth keeping on going. If necessity requires contractor to perform any services on client's property, ethics. Sorry, did I? Oh, sugar. Some company beginning with E. Navin. I don't. I just need to check. No, there's no message. Okay. Where were we? Where were we? I'm lost now. Where were we? Well, we were there. If necessity requires any services on client's property, well, I suppose apparently there's a rental of in a what do you call it? A strip mall. So that could be the client's property. Or requires contractor to interact with any of the client's employees. He's got employees, customers, vendors, affiliates, or members of the public. Contractor shall comply with all the client's policies and regulations, which may change. I wonder if he ever provided a copy of such policies and regulations. This agreement will become effective on the effective date and will continue in effect until the something reloaded project, I don't know what that could have been, provided for in this agreement has been completed to client's reasonable satisfaction unless terminated earlier as provided in this agreement. That's a weird term. This agreement will become effective and will continue in effect until the reloaded project has been completed. But surely it's a continuing project, so how can it ever have been complete anyway? Compensation and expenses. In full consideration for the services described in this agreement to be performed by contractor, client agrees to pay contractor 50% of net revenues payments for the delete. Oh, I don't know. Should I put a bit of white over that? Reloaded. No. YouTube channel. Upon satisfactory completion of the term, payments will be made in the following manner. By PayPal within 30 days after payment is received from YouTube. If work was not satisfactorily completed, client has 14 days to notify contractor, and contractor has 14 days to correct the deficiencies. I wonder if any notices were sent. Contractor will be responsible for all expenses incurred in performing the services under this agreement. Compensation paid to contractor is in full consideration of any services performed and any expenses incurred while performing said services. Key provisions. Contractors enters into this agreement will remain throughout the term of this agreement as an independent contractor. Contractor agrees that neither contractor nor any contractor personnel is or will become an contractor. Okay, yeah, contractor is this individual called Colin, isn't he? So Colin would have had personnel. He might have had rats in that. Oh no, I shouldn't personalise this. Contractor nor any contractor personnel is or will become an employee, partner, agent or principal of client while the agreement is in effect. So no employment. This agreement does not in any way create any type of partnership, association, joint venture or other business arrangement between the parties. Now that is weird to me, because if that was the case, then because surely something that pays 50% of net revenue payments on the face of it is a joint venture, if not a partnership. But okay, I'm not a Nevada lawyer. I'm not a lawyer, so I did deal with partnerships and sole traders and stuff and other trading agreements, but this agreement does not in any way. The contractor agrees that neither contractor nor any contractor personnel shall be entitled to the rights or benefits afforded to the client's employees, including but not limited to disability or unemployment insurance, workers' compensation, medical or life insurance, sick leave, compensation time, overtime, retirement or holiday benefits, vacation time, profit sharing, bonuses, or any other employment benefit. So not entitled to anything apart from the 50%. Contractor is responsible for providing at contractor's own expense, disability, unemployment. So he had to provide all of these. He had to provide all of those. Permits, licenses. Interesting. Nothing in this agreement shall be construed to give contractor or contractor personnel any authority to represent that such person is an employee of client, to bind client with respect to contracts or representations or any other matters, to represent client before any court or government or regulatory authority, without the express written authorization of the client. Non-exclusive relationship. So contractor may represent other people. Okay, so that's all late. Contractor acknowledges that this is a non-exclusive engagement and that client retains the right to appoint additional contractors as client in its sole and unrestricted judgment, may from time to time determine. Contractor is solely responsible for paying when due any taxes, including estimated taxes, incurred because of the compensation paid by client to contractor for services under this agreement. So that's suggesting that this pretend person called Colin, who may or may not have signed this agreement, was responsible for taxes. Contracted on behalf of himself and any successors, assigns and heirs, agrees to defend, indemnify and hold client, including clients, employees, officers, directors, harmless from and against any damage, claim, losses, fee, assessment, interest charge or penalty incurred by or charged to client as a result of any claim, cause of action or assessment by any government agency for any non-payment of late payment by contractor of any tax or contribution. So that's the clause that Chile will rely on to say it's not my job to have deducted taxes. Workers' compensation. Contractor agrees to provide workers' compensation insurance. Oh, that's just for his employees. Okay. Use of employees or subcontractors. Well, we know Colin never got round to employing anyone, so we don't really need to read that. Termination of agreement. Nabin, it's a fictitious Colin. I should stress, it's someone called Colin, perhaps, maybe signed this agreement. I don't know. It's not like a court document where I can verify the source. Unless otherwise terminated as provided in this agreement will continue until the services provided for in this agreement have been fully and completed. I mean, I just don't understand how the services could have been fully and completed to the satisfaction of the client. Because if you remember those services at the top there's no sort of, when is he complete sending out free trifolds? When is he complete moderated? It all seems a bit sort of slapdash. And shall then terminate unless renewed in writing by both parties. Well, where's the end? I don't see the end. Hello. I'm just picking up and hello. And they agreed to confirm and fairly negotiate new terms once per calendar year. Client may terminate this agreement with cause provided written notice is given to contractor 14 days in advance. Client may also terminate this agreement immediately if contractor breaches this agreement. Upon an early termination, contractor shall receive a prorated payment for services actually rendered to client's reasonable satisfaction prior to the termination date. See, I'm wondering because maybe this was the first agreement. I don't know. Because I've heard X amount per month, so who knows? Contractor may terminate this agreement without cause, provided written notice is given to client 14 days in advance. Contractor must train his replacement, even if replacement is not found within 14 days. Oh my. I don't think I'd have signed such a contract. Prorated. Prorated. Should be prorated. 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 Did I say prorated? Sorry. After training his replacement, contractor will receive residual payments for a period of time of his regular compensation plan under the following schedule. So if he put 1 year and he passed it on, assuming this contract was, he'd have got 3 months payout, but he didn't work a year. Upon expiration, let me read that one. Cannot even take this to court because I doubt he's registered as a business and would risk exposure his grifting. It's under this hypothetical contract that may or may not exist was between a company that began their name with ethics. Proprietary rights. So that's just going to be everything that a contractor did probably belonged to the client. Yeah. Contractor agrees to help client obtain patents and copyrights for any new developments, including a Fifth Amendment credit card. This includes providing data plans, specifications, descriptions, documentation, and other information, as well as assisting client in completing any required application or registration. Contractor waives any moral rights contractor has, including but not limited to any rights of integrity, Paternity? Paternity? Am I reading that? Am I reading that correctly? Contractor has including, but not limited to, any rights of integrity, paternity, disclosure and withdrawal related to any assignment of intellectual property rights. I mean, that's a strange term to me, but maybe that's an Americanism in terms of intellectual property rights. Right. Oh dear. Now, there was in this hypothetical contract that may or may not be existing, may and may not be a basis of any contract that was signed. There is a confidential information clause. So if such contractor did sign such a document as this, he may well have breached this one. Contractor may gain access to confidential and proprietary information about client and its affairs and operations. That's what I thought, Navin. So if this was signed, this has definitely been breached by the acts of Colin. I'm not going to read word for word, but yeah. And he'll indefinitely maintain clients' confidential information in the strictest confidence and will not disclose it. And anyone else that the contractor contracts with should be under the confidentiality agreement. Right. That's probably irrelevant. Right. During the term of this agreement and for a period of 1 year thereafter, contractor will not do or cause anyone on contractor's behalf to do either of the following: call on, solicit, or take away any of the client's customers or potential customers contractor became aware of as a result of performing the services under this agreement. So that client list of all the people that he sent trifolds to, he can't solicit them. Solicit or hire away any of the client's employees or contractors contractor became aware of as a result of performing the services under this agreement. Right, I've obviously whited out what was here. If any provision of this agreement is held by a court of competent jurisdiction to be invalid, void, or unenforceable, the remaining... Okay, so, yeah. Any dispute, controversy, shall be solely and finally settled by arbitration administered by the American Bar Association. I thought they were a corrupt bunch of people. Arbitration. The arbitration shall take place before a panel of 3 arbitrators sitting in Clark County, Nevada. The language of the arbitration shall be in English. The arbitrators will be bound to adjudicate all disputes in accordance with the laws of the state of Nevada. So this is under Nevada law. There's a warranty that he was legally capable of entering the agreement. Right, there's a force majeure clause. I won't read that. Right. And it supersedes all other agreements. Okay, there you go. So that is that is maybe something that surfaced. As I say, I don't know if it is, I don't know if it isn't. But you joined me to go through it, and I went through it for the first time with you. Right, number 2. It is the 24th of October today, isn't it? Is that coming out on the screen? Just about. The defendants in the James Springer, that is James Freeman action, filed 2 motions. Now, I do have those motions. I could read them out in full, but I don't really want to. And the fact that we have an order from the judge concerning the motions, I don't really think it's worth it. Because if we read the order, can I highlight that? No, I can't highlight that. So you've got the 2 motions that were filed on the 23rd. And I need to have the, not that one, sorry. I lost it. Why can't I go back up? Why isn't my chat allowing me to go back up? Scroll on my chat is not working, so I can't go back up for some reason. Oh, there it is. I've got it back. Okay. It's hello, nasty. I did see that one. Right. So we have an order by the district judge striking 52 defendant's motion to dismiss. Number 1, dismissal for failure to state a claim, qualified immunity as to individual defendants, and no supplemental jurisdiction as to state claim, and striking 53, defendant's motion to dismiss. Number 2, dismissal for lack of service, for lack of jurisdiction, and for spoliation of evidence. Defendants shall have until and including October 27, 2023, to file a single consolidated motion to dismiss and brief in support, combining all arguments in a single filing. It is so ordered. So these 2 motions, but underneath, which I do have, and as I say, I don't really want to read them out, because there's going to be a new motion, and maybe we'll read that out. Unless I see either in the chat now or in the comments later that you'd like me to read it out. So that's James Springer. What else have I got here? I don't know. So those are James Springer's motions. The last one was Jose de Castro. Now, this came out in the, late last night for me. I hate doing this because I sound like that fool from Indiana, is it? For public safety or something like that. Now, put a 1 in the chat if you'd like me to read out the motion. Chili's motion. I put 2 pages. I know it's been read out elsewhere. Put a 1 in the chat if you'd like me to read it out. I haven't read it myself, so I'll be reading it for the first time if I do read it out. But I'll wait for you to tell me in chat. Whilst I'm waiting for you, I'm going to have a little look and see if my spreadsheet is working and see whether hang on, I need to clear that, don't I? Clear that column. You're not seeing what I'm doing at the moment. Oh dear, it looks like it has worked. Oh dear me. Okay. So we have Tadpole 99 in the chat. Hello, Alpha. We have Tadpole 86 in the chat. Hello, Timo. We have Tadpole 77. There's a problem with Tadpole 77, and I don't see her in here. Alice. So Alice Caffrey, you were second to ask for Tadpole 77. So I've done you Tadpole 77.0, or, yeah, I'm going to read it out. Or you'll have to choose another number. Who else have we got? So we've got Goddess, who is Tadpole 77. Maybe I've got to and we've got Tadpole 45087. No. Right. Sorry. I got that wrong, Scott. For some reason, and I can't explain the reason, Scott Ammo, Tadpole 106. Yeah, Frogleg 77's gone, Alex. Frogleg 77 gone. So I can give a 77.0. Vlad is Frogleg 77. Now, as I'm obviously in the early stages of testing this, and I was quite pleased to have picked up some of you in the chat and could work out that you're in the chat. Let me just do, I'll update it just once more. Have I lost the, oh dear me. Why can't I see it? There we go. Okay. Paste. All right. I see another one. We got Tadpole 256 and a half. So hello, Bruce. Anyone else crept in? Looks like no. No, I was going to say Mr. Fox, but you're not a member yet, so yeah, no. 10. Is it said 10/6? Am I saying that right? Or 10/6? Am I saying that right? Anyhow, I got a few of you, so if you want to join, just fill in the form. Right, on to Chile. We'll read this out. Obviously, I'll understand 100% if you don't want to stay with me for this, if you've heard it before. All right, so this is the judge's order. So this is Jose's suit against, well, it was the state of Nevada. They've dropped out already. So it's against the LVMPD and other officers. De Castro contends the officers unreasonably searched and seized him because he was video recording a police encounter. The defendants moved to dismiss all claims except De Castro's claims for excessive force under the Fourth Amendment and state law claims for assault and battery. Tory filed a joinder to the motion. De Castro opposes dismissal or alternatively requests leave to amend. I grant the motion in part with leave to amend in part. I'm not going to read through the background of the event, although no, maybe I will, because it's the judge's interpretation of the background of the event. So In March 2023, De Castro observed an interaction between defendant Bork and an unknown woman, whom the complaint refers to as Jane. De Castro began recording the incident on his phone from approximately 10 feet away from Jane and asked her if she was okay. Bork left his patrol car and told De Castro to back up, which De Castro did by moving back another 5 feet. Bork told De Castro to back up further, but De Castro stated that he had a right to be there and was a member of the press. Bork threatened to detain De Castro for obstruction and stated that Jane deserved privacy. De Castro repeated that he was a member of the press, at which point Bork indicated he was detaining De Castro. Bork told Jane to leave and then approached De Castro. Bork placed De Castro under arrest, patted him down and placed him in handcuffs. 3 other officers arrived on the scene. De Castro continued to protest that the officers had no valid reason to detain or arrest him. According to the amended complaint, Bork accused De Castro of being on drugs based on the colour of his skin. One of the other officers told De Castro to look only straight ahead, and when De Castro did not immediately comply, the officer squeezed his elbow. De Castro complained about the pain this caused and about the order that he must look in only one direction. The officer squeezing his elbow stated that it was policy to squeeze the elbows of people who did not comply with orders. De Castro alleges that he asked the other officers for help and told them he would sue them for failing to intervene, but they ignored him. De Castro claims his elbow was squeezed for 15 minutes before he could not tolerate it further and tore his elbow away from the officer. Tory, who the amended complaint identifies as a supervisor, arrived on the scene. According to the amended complaint, Tory authorised the officer's conduct and told De Castro that he should be arrested to discourage his behaviour. At some point during the encounter, Bork told De Castro that First Amendment auditors, people who record police interactions, had been known to drop their recording device and pull out a weapon to fire at officers. Another officer stated that De Castro needed to be patted down, even though he had already been patted down by 2 other officers. According to the amended complaint, the officer spread De Castro's legs uncomfortably wide and struck him in the testicles. De Castro was then placed in the police car in an overly tight seatbelt. He was searched and transported to the jail, but he was released about 5 hours later with citations. He claims that the defendant Sorensen repeatedly threatened to charge De Castro based on De Castro's dog being left in a car during this incident. De Castro alleges that the officers acted the way they did because De Castro had recently covered stories about LVMPD that went viral. Yeah, they really went viral, Chile, on the internet. Based on these allegations, De Castro brings claims under 42 U.S.C. 1983 for unreasonable search and seizure, equal protection, and First Amendment retaliation against individual officers. He asserts entity and supervisory liability under Section 1983 against the state of Nevada, that's gone, LVMPD, and Tory. He asserts a claim of intentional race and political viewpoint discrimination under 42 U.S.C. 1981 against all the officers. He also brings state law claims for assault, battery, false arrest and imprisonment, invasion of privacy and negligence against all the defendants. 2. Analysis. Summary judgment is appropriate if the movement shows there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. That's citation. A fact is material if it might affect the outcome of the suit under the governing law. Citation. A dispute is genuine if the evidence is such that a reasonable jury could return a verdict for the non-moving party. The party seeking summary judgment bears the initial burden of informing the court of the basis for its motion and identifying those portions of the record that demonstrate the absence of a genuine issue of material fact. Citation. The burden then shifts to the non-moving party to set forth specific facts demonstrating there is a genuine issue of material fact for trial. Citation. To defeat summary judgment, the non-moving party must produce evidence of a genuine dispute of material fact that could satisfy its burden at trial. I view the evidence and reasonable inferences in the light most favourable to the non-moving party. So that's in the light most favourable to Chile. A. Section 1983. To state a claim under Section 1983, the plaintiff must allege a violation of his constitutional rights and show that the defendant's actions were taken under colour of state law. Citation. The parties do not dispute that the defendants acted under colour of state law. Fourth Amendment seizure based on the arrest. The defendants contend De Castro's Fourth Amendment unreasonable seizure claim based on the arrest fails because, by the amended complaint's allegations, the officers had probable cause to arrest De Castro for obstruction. They contend that De Castro was too close to the scene, was interacting with Jane, who had no choice to avoid De Castro because she was being detained by the police and would not back up when ordered to do so. Alternatively, the defendants argue that Bork is entitled to qualified immunity because no clearly established law put him on notice that it would be unlawful to arrest an individual who interfered in a traffic stop and refused to obey orders to back up. De Castro responds that the defendants have improperly characterised the amended complaint's allegations. He did not allege that he was still close enough to interfere with Bork's interaction with Drain, and they had no probable cause to detain or arrest him for the undefined offence of obstruction. He also argues qualified immunity should be decided at summary judgment, not dismissal. To allay the risk that fear of personal monetary liability and harassing litigation will unduly inhibit officials in the discharge of their duties, government officials performing discretionary functions may be entitled to qualified immunity for claims made under 42 U.S.C. 1983. Citation. Qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. Citation. In ruling on a qualified immunity defence, I make a two-pronged inquiry into whether 1. The defendant violated the plaintiff's constitutional right, and 2. Whether that right was clearly established. Citation. I may consider these two prongs in any order. In determining whether the plaintiff has alleged deprivation of a constitutional right, I take as true the facts alleged by the plaintiff. Citation. The plaintiff bears the burden of showing that the right at issue was clearly established. A right is clearly established if it has been settled by controlling authority or a robust consensus of cases of persuasive authority that clearly prohibits the officer's conduct in the particular circumstances with a high degree of specificity. Citation. I may not define clearly established law at a high level of generality because that avoids the crucial question whether the official acted reasonably in the particular circumstances that he or she faced. However, a plaintiff need not establish that a court previously declared the defendant's behaviour unconstitutional if it would be clear from prior precedent that the conduct was unlawful. Citation. Additionally, a plaintiff may meet his burden on the clearly established prong by showing the defendant's conduct was such a far cry from what any reasonable official could have believed was legal that the defendants knew or should have known they were breaking the law. Citation. Because qualified immunity is an immunity from suit rather than a mere defence to liability, the Supreme Court has repeatedly stressed the importance of resolving immunity questions at the earliest possible stage in litigation. Citation. Consequently, qualified immunity can be resolved at the motion to dismiss stage if it can be determined, based on the complaint itself, that qualified immunity applies. Citation. The parties dispute whether the officers had probable cause to arrest De Castro for obstruction. Citation. Stating that under the Fourth Amendment, police officers must have probable cause to make a warrantless arrest. Probable cause exists when, at the time of arrest, the officers know reasonably trustworthy information sufficient to warrant a prudent person in believing that the accused had committed or was committing an offence. Citation. Even if the officers were mistaken that probable cause to arrest existed, they are nonetheless immune from liability if their mistake was reasonable. Citation. Even taking the amended complaint's allegations as true, the officers had probable cause to arrest De Castro for obstruction. Nevada law makes it a misdemeanor for any person after due notice to willfully hinder, delay or obstruct any police officer in the discharge of official powers or duties. By the amended complaint's allegations, Bork was in a police interaction with another member of the public, Jane. De Castro started recording the incident on his phone, moved within 10 feet of Jane and spoke to her. Although De Castro obeyed Bork's first command to back up, Bork told De Castro to back up further and threatened to detain De Castro for obstruction, but De Castro refused to do so. Bork thus had probable cause to believe that after due notice, De Castro was hindering, delaying, or obstructing Bork in the discharge of his duties. I have seen one or two saying, well, this is going to affect his criminal case. Different jurisdictions. Yeah, I mean, it's probable that the judge in his criminal case will conclude the same, but, you know, you can't just say, well, because this judge says this, he's going to be found guilty. He's going to be found guilty on the evidence provided at trial. Sorry, I digressed there. Even if the officers lacked probable cause, they were reasonably mistaken that probable cause existed. De Castro has pointed to no clearly established law that Bork could not order him further back from the scene, or that any reasonable officer under the circumstances would know that they would violate the Fourth Amendment if they arrested De Castro for refusing to obey Bork's command. I therefore dismiss this claim with prejudice because amendment would be futile. Citation: futility of amendment can by itself justify the denial of a motion for leave to amend. So that one's gone. 2. Equal protection. The defendants argue that De Castro has not plausibly alleged that he was treated differently based on the colour of his skin, which they note the amended complaint does not identify. They also argue that being a member of the press is not a protected class for equal protection purposes. De Castro responds that he has adequately alleged a Class of 1 equal protection claim. To state an equal protection violation under Section 1983, a plaintiff must allege that the defendants acted with an intent or purpose to discriminate against the plaintiff based upon membership in a protected class. Citation: additionally, a plaintiff can state an equal protection claim even if not based on class discrimination, if he claims that he has been irrationally singled out as a so-called Class of 1. Citation: to allege a Class of 1 claim, the plaintiff must plausibly allege that the defendants 1. intentionally, 2. treated him differently than any similarly situated persons, 3. without a rational basis. Citation: a Class of 1 plaintiff must be similarly situated to the proposed comparator in all material respects. Citation: race. De Castro does not plausibly allege an equal protection claim based on race. De Castro does not identify as race, and although he alleges that he was asked if he was on drugs based on the colour of his skin, there are no facts to support the allegation that De Castro's race motivated the question. As currently pleaded, this allegation appears to be De Castro's unsupported conclusion about why the question was asked. However, because it is not clear that amendment would be futile, I grant him leave to amend this claim. Citation: as a general rule, dismissal without leave to amend is improper unless it is clear that the complaint could not be saved by any amendment. So he's got a chance on that one. Class of 1. The amended complaint does not plausibly allege a Class of 1 theory because De Castro does not allege that others filmed police interactions within 15 feet, refused officer commands to back up, and were nevertheless not arrested. He therefore has not plausibly alleged that he was treated differently than others similarly situated. Because it is not clear that amendment would be futile, I grant De Castro's leave to amend this portion of his equal protection claim. So he can amend Class of 1. Member of the press, political viewpoint. De Castro does not respond to the defendant's argument that being a member of the press or expressing a particular political viewpoint are not protected classes for equal protection purposes. He therefore consents to the granting of this portion of the defendant's motion. However, it does not appear that amendment would be futile. Citation: I therefore grant De Castro leave to amend this portion of his equal protection claim. So that's all the equal protection claim he can amend. 3. First Amendment retaliation. The defendants argue this claim fails because they have probable cause to arrest De Castro, and De Castro has not plausibly alleged that he was arrested, whereas simply situated individuals who had engaged in protected speech were not. De Castro responds that he has adequately alleged that he was arrested, whereas similarly situated individuals engaged in the same sort of protected speech had not been arrested. Police officers cannot retaliate against individuals for exercising their First Amendment rights. Citation. To state a First Amendment retaliation claim, a plaintiff must allege 1. He engaged in constitutionally protected activity. 2. As a result, he was subjected to adverse action by the defendant that would chill a person of ordinary firmness from continuing to engage in the protected activity. And 3. There was a substantial causal relationship between the constitutionally protected activity and the adverse action. A plaintiff alleging an arrest was retaliatory under the First Amendment typically must allege the officer lacked probable cause. However, a plaintiff may state a First Amendment retaliatory arrest claim even where the officer had probable cause if he can also allege officers typically exercise their discretion not to arrest under similar circumstances. This exception applies only when a plaintiff presents objective evidence that he was arrested when otherwise similarly situated individuals were not engaged in the same sort of protected speech had not been. Citation. As discussed above, the officers had probable cause to arrest De Castro. He therefore must plausibly allege facts that officers typically exercise their discretion not to arrest under similar circumstances involving individuals who were not recorded in a police encounter or were not protesting their own arrest. He has not done so. Consequently, I dismiss this claim with leave to amend. So he can amend that one. Entity and supervisory liability. The defendants argue that if the officers did not violate any constitutional rights, then the entity and supervisory claims fail as well. Alternatively, they argue that De Castro's allegations are conclusory and contradict entity liability because he alleges the individual officers violated LVMPD's policies during their interaction with him. De Castro responds that he has adequately identified the policies, how they were deficient, that they were deliberately indifferent to his rights, and that he was injured as a result. He also notes that the motion made no specific argument about his supervisory liability claim against Tory. A. Entity liability. There is no respondeat superior liability under Section 1983, citation. Rather, to impose a liability on an entity like LVMPD, plaintiff must allege 1. That he was deprived of a constitutional right, 2. The entity had a policy, 3. The policy amounts to deliberate indifference to his constitutional right, and 4. The policy is the moving force behind the constitutional violation. Citation. A plaintiff can show a policy through 1. An expressly adopted official policy, or 2. A long-standing practice or custom that is so widespread as to amount to an official policy. The second means of showing a policy cannot be based on isolated or sporadic incidents. Citation. Rather, the plaintiff must plausibly allege practices of sufficient duration, frequency, and consistency that the conduct has become a traditional method of carrying out policy. Citation. The amended complaint identifies various policies, but only in conclusory terms, without any plausible factual basis to assert that these policies or practices exist. To the extent that De Castro is relying on what happened in his own situation to support a custom or practice, a single incident is insufficient to show a widespread custom or practice. I therefore dismiss the entity liability claim against LVMPD. However, I grant De Castro leave to amend. Just read this footnote. Right, she's asking for clarification there. De Castro does not appear to be relying on this theory, but if I misunderstand his amended complaint, he has to leave to amend and add facts to support the theory. Okay. Supervisory liability. The defendant's motion does not specifically address supervisory liability against Tory, instead grouping supervisory liability with the entity liability analysis. However, supervisory liability is different than entity liability. Citation. stating that a supervisor may be liable if he participated in the violation, directed it, or knew of his subordinate's violation and failed to act to prevent it. Consequently, the motion does not sufficiently support dismissal of this claim. But because I am granting De Castro leave to amend some of his other claims, I also grant him leave to add factual allegations to further support his supervisory claim against Tory, if he so chooses. So another one with he can amend. B. Section 1981. The defendants argue that De Castro has not alleged he is a member of a protected class or that he attempted to contract with the defendants. De Castro responds that police services were not provided to him in an equal way and that he was not able to use the parking lot or restaurant where the incident took place. Section 1981 prohibits race discrimination in making and enforcing contracts. This includes the making, performance, modification and termination of contracts and the enjoyment of all benefits, privileges, terms and conditions of the contractual relationship. Citation. De Castro has not alleged his race or any non-conclusory facts that he was subject to race discrimination. He also does not allege a contract. He cites no authority for the proposition that members of the public individually contract for police services, nor has he alleged that he entered into a contract to use the parking lot or eat at the restaurant, or that the officers intentionally interfered with his use of the parking lot or restaurant based on his race. I therefore dismiss this claim. Although it appears highly unlikely that De Castro will be able to plausibly allege a claim under Section 1981, I grant him leave to amend. He's been very kind to De Castro. However, I direct Castro to the Ninth Circuit recent decision in Yoshikawa v. Segurent. Under that case, a plaintiff seeking to enforce rights secured by Section 1981 against a state actor must bring a cause of action under Section 1983. Consequently, if De Castro amends this claim, he must recast it as one brought under Section 1983 for a violation of Section 1981. C. State law claims. False imprisonment. The defendants contend this claim fails because the officers had probable cause to arrest De Castro for obstruction. Alternatively, the defendants argue that they are entitled to discretionary immunity. De Castro repeats his arguments as to why probable cause did not exist. He also argues that discretionary immunity does not apply because the case on which the defendants rely is distinguishable. De Castro has not plausibly alleged a false arrest claim because, as discussed above, the officers had probable cause to arrest him. Citation. Additionally, the defendants would be entitled to discretionary immunity under Nevada law because the decision to arrest De Castro was discretionary and based on policy consideration of enforcing the criminal laws. Citation. Holding that an officer's decision to arrest based on matched description in a facially valid warrant was entitled to discretionary immunity. Another citation. Holding that discretionary immunity applies if the officer's decision involved an element of individual judgment or choice, and 2, was based on considerations of social, economic, or political policy. I therefore dismiss the false imprisonment claim with prejudice, so I can't bring that one back. Invasion of privacy. This claim is based on the officers searching De Castro without legal justification. The defendants argue this claim fails because it is based on a search incident to his arrest, which was lawful. Incidental to his arrest? Anyhow. De Castro responds that there was no probable cause for the arrest and thus the search was not lawful. As this claim also turns on whether there was probable cause, I dismiss it with prejudice. That one's gone. Negligence. The defendants argue this claim fails because they have probable cause to arrest De Castro and because they have discretionary immunity. De Castro responds that the defendants overlook his claim related to vicarious liability and that discretionary immunity does not apply to individual officers. In the amended complaint, De Castro alleges that the defendants were negligent by not using due care in arresting him, retaliating against him, using force and engaging in biased policing. To the extent this claim is based on the arrest or search, I dismiss it because the officers had probable cause and would have discretionary immunity. As for biased policing, De Castro has not plausibly alleged either racial discrimination or First Amendment retaliation, so I dismiss this portion of the claim with leave to amend. But I do not dismiss the negligence claim to the extent it is based on the officer's use of excessive force, because the defendants did not move to dismiss any claims based on their use of force. Apologies if you can hear the garage. State constitutional claims. In his response to the motion to dismiss De Castro, asserts that he has brought state constitutional claims, but no such claims are pleaded. Because I am granting De Castro leave to amend some claims, I grant him leave to add state constitutional claims. Citation. I do not grant De Castro leave to add claims for unreasonable search or seizure based on his arrest under the Nevada Constitution because the officers have probable cause. But I do not preclude De Castro from asserting an unreasonable seizure claim based on the officer's alleged use of excessive force while effecting that arrest. That poor little Pinky. The amendment. To assist De Castro, who is pro se, in crafting an amended complaint, I advise him that his second amended complaint must contain 1. A short and plain statement of the grounds for the court's jurisdiction. 2. A short and plain statement of the claim showing that he is entitled to relief. 3. A demand for the relief sought. The second amended complaint must be a complete document in and of itself and will entirely supersede the amended complaint. Any allegations, parties, or requests for relief from prior papers that are not carried forward in the second amended complaint will no longer be before the court. De Castro should support each claim with factual allegations because all complaints must contain sufficient allegations of underlying facts to give fair notice and to enable the opposing party to defend itself effectively. Citation. The second amended complaint should set forth the claims in short and plain terms, simply, concisely, and directly. I encourage De Castro to review the defendant's motion to dismiss in crafting a second amended complaint to avoid the defendants making similar arguments about alleged infirmities in his second amended complaint. Conclusion. I therefore order that the defendant's motion to dismiss is granted in part. The following claims are dismissed with prejudice. The Fourth Amendment, unreasonable search and seizure based on the arrest and search, false imprisonment, invasion of privacy, negligence based on the arrest and search. So they're all gone. The following claims, obviously, I say they're all gone. Knowing Chile, he'll appeal this to a higher court. I think, yeah, we'll be able to. Well, I'm assuming he will be able to appeal them. Knowing him, he will, but the following claims are dismissed without prejudice and with leave to amend. Equal protection, First Amendment retaliation, entity liability under Section 1983, Section 1981, negligence based on biased policing. However, the motion is denied as to the supervisory liability claim and it remains pending. All claims that are based on the alleged use of excessive force also remain pending. I further order that plaintiff Jose De Castro may file an amended complaint consistent with this order by November the 22nd, so we give him 1 month. If De Castro does not file an amended complaint by that date, then the case will proceed on the claims for his Fourth Amendment excessive force, supervisor liability, assault battery, and negligence based on excessive force. So, whoever is advising him has got some work to do. Thank you, Internet God. That's brilliant. That's brilliant to know. I'm glad that you were here. Now, let me just see if we've been joined by any other frog legs or tadpoles. Paste the chat into there. And I should be able to see if anyone else has come in. We've had Scott before, we've had Goddess before. Or Paul B. Now, Paul, did you pick a number? I can't remember. Paul, you said you wanted to be a frog leg, but you never gave me a number. So, Paul, you need to let me know. So that was Paul we dealt with. Is there anyone else who's come in? Dealt with everyone else. But it's very nice to have the few frogs' legs and the few tadpoles that I've got. Yeah, if you want to type it in now, I'll No, you didn't. Someone put 7 in the chat. Is that they want Paul to be 7? Goosebump. 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 Let me search for Goosebump. Goosebump. Now, Goosebump, I don't see you returning a form. So I'm wondering if you put the name, your YouTube name, on the form. Nasty Nathaniel. If you can you complete my form, Nasty? But let me just check. Just checking my numbers. That number looks... Oh, you didn't ask for a number. Yes, you can be a frog leg, but can you complete my form? And then I confused you with the 427 after it. 34, Paul. I've got you. That one's done. Don't worry, you don't have to tell me. But Goosebump, yeah, I can't see you in the responses. So and Google Forms normally, well, I've never seen a response not come through on the form. So you might have just put incorrect name in place. Yeah, you need to complete the form. And 69 obviously has been very popular for some unknown reason. And we have Frogleg 69, who is Tom Peters. So Tom Peters got the frog leg. And according to Asia, is Tadpole 69. So perhaps you two could get together, you know. So unfortunately, 69 has gone. Right. No, you can't, Internet God, you can't. 69 has gone. Why is 69 popular? For some reason, I was accepting. Yeah, just make sure you put Make sure Goosebump 801 is in there somewhere, and I'll pick it up. But I can't see you there. So, anyhow, 69 and a half. I am allowing some decimals. Where is the form? It should be linked to this live stream. It should be linked in the description to this live stream. Let me just check that's the case. Can I? If it's not there, I'll check it. I'm not sure if 6969 has gone. It might have gone, but I'm not sure. But complete your form. Yeah, 77. 77 has gone. 77. I've had 377. So Frog Leg 77 and Tadpole 77 are gone. So that's unfortunate. I can't think of another part of a frog to give another 77. Right. I think I've done enough. Thanks for joining me, especially if you stay for the chili, because I know it's been done before. I think I do. Yeah, sorry, I was being sarcastic. So I was being sarcastic when I said I don't know why 69 is popular. As I said, there were those stream motions, but we're going to get a combined one anyway, so we might as well wait for that. Thanks for joining me. There was another little bit in, if you're interested, and I'm just trying to think, Christopher Reiter and Tiffany Napier. That's Miss Constitutional, I think, and For Public Safety YouTube channels. Their Section 1983 lawsuit regarding their raid, they have a lawyer. There is a lawyer appointed. 69 refers to the new moon landing. Does it, Paul? Yeah. Unfortunately, I was alive at the time. What was I saying? Yeah, they have appointed a lawyer, and their lawyer is trying to get people who are unserved into the lawsuit, so they may get more than the 2 defendants that they've got at the moment. So wait and see on that one. Right, I don't see the link. If it's not there, I'm going to put it there at the end of this stream. So I will put For Public Safety and Official Misconduct. Yeah. Thanks, Alex. I almost got it right, didn't I? Didn't I say For Public Safety? Oh no, did I say For Public? I don't know. Too many publics. Right, I'm going to go. Thanks, Alex, for clarifying. Toshi, just let me check. Toshi 17. I will look at the form and make sure it's receiving, but I don't see Toshi. So hang on. Yeah, sorry, I see Toshi and Goosebump. I see you. Sorry, Goosebump. I've found you. You wanted number 8. I forgot to copy that over before I started today. I must automate that bit. Number 8 looks good. So you wanted to be a tadpole number 8, Taco and Yoshi. You want to be frog leg number 17. Let me just check. Yep, frog leg number 17. So we got frog leg number 17, and we've got tadpole number 8 with us. That's Goosebump and Taco. Okay. I'll catch you later. Thanks for joining me.